Good evening, Captain Retired Matt Edwards here with the next installment of the Observation Post Facebook Live Weekly Report. Now, I'll wing through 3 different items on my numbered list, but one of the things I'll talk about a lot tonight is the Canadian Forces Ombudsman report in 2003 and a follow-up letter from 2007. Now, that's partly in relation to the fact that the Ombudsman failed to call me today. I thought they were supposed to call me at the 21st at 1 o'clock. Looked at the email later, it was 1:30. Then I saw another email that said 3 o'clock. 3 o'clock came and went, Newfoundland Standard Time. No call, so I said, well, maybe he meant 3 o'clock Ottawa time. 4:30 Newfoundland time passed along and nobody called. So I'll have to try him again later. Not that I expect very much from the Canadian Forces Ombudsman. Now, the 3 issues that I'll discuss from my numbered list. Number 469 on my numbered list is compare my Canada Pension Plan Disability flat rate to the Public Service Superannuation Act clawback. Now, the flat rate is the same for everybody on Canada Pension Plan Disability. Now, my backup position for clawbacks is that they can't claw back the flat rate. Now, that's based on the fact that the flat rate is meant for disabled contributors to the Canada Pension Plan and not for pensions and insurance to save money. Number 470. Can we sue in tort for Canada Pension Plan Disability estimation based on misrepresentation? Now, there's the tort of misrepresentation. There's the tort of negligence. There's the tort of fraud. There's all kinds of torts where people owe other people a duty of care. Now, when insurance companies and the government wants to save money, they estimate the Canada Pension Plan Disability, so they lower the insurance payment prior to Canada Pension Plan Disability approval. Now, that is very problematic because they're putting the cart before the horse. They're crossing the bridge before they come to it. There are many trivial, trite sayings, everyday sayings about things that you have to wait for something to happen before you do something. You're not supposed to get ahead of yourself. But these people estimate things like how much a Canada Pension Plan Disability is, and you can't get that amount. Okay, they based the maximum clawback for the Canada Pension Plan Disability on a 47-year career with the flat rate, and they said this is the maximum Canada Pension Plan Disability rate, so we're going to estimate at this amount, and that way they force people, they coerce people into trying to get Canada Pension Plan Disability. You don't get the maximum. You can't get the maximum unless you had a full working career. Number 471. I'm winging through these really fast because I want to get to the main topic. I'm going to go through the 2003 report put out by the Canadian Forces Ombudsman, and it occurred to me today, I wonder if they're grossly incompetent or if they're in on it with the government. Okay, number 471. Gill Supreme Court of Canada, 1973, and a contract of utmost good faith. Now, in the Gill versus Canadian Pacific Railway, 1973 Supreme Court of Canada case, the Canada Pension Plan was involved in that trial, and it wasn't very long after, only 7 years after the Act came into effect. And the Supreme Court said that basically the Canada Pension Plan is a social insurance, and that the contributions are the same as a premium, and the Act is the same as a contract of insurance. Now, you see, insurance contracts are supposed to have utmost good faith implied into them. But the way that the Canada Pension Plan is administered, well, I'm talking mostly about the disability portion. I have no idea how they administer the retirement pension, but I assume there's no problems because everybody is going to get that without a problem because they paid into it, they retire, and the rules are the rules. But the Canada Pension Plan disability has always been seen by many people as a form of welfare. But it's not welfare. You paid for it. It's in the actuarial report put out by the Canada Pension Plan. They describe the Canada Pension Plan disability as the largest long-term disability plan in Canada. And that's true. But the problem is they set a very high bar for the insurance. You had to be any occupation disabled, which in the military is 3A disabled instead of 3B disabled. In order to get your Canadian Forces Superannuation Act pension, you just had to be unable to do your own trade. In order to get the Canada Pension Plan disability, you had to be unable to do any trade. That's a big difference. In my experience from researching this, about 16% qualify for that definition. Now that's backed up by the RCMP Actuarial Report and the RCMP Superannuation Act pension put out by the Office of Superintendent of Financial Institutions. In 1966, they said that they estimate only 10% of those Royal Canadian Mounted Police members who become disabled will qualify for the Canada Pension Plan disability. And by 1974's report, they estimated only 25% of the RCMP members who are too disabled to do their job would get a Canada Pension Plan disability pension. Now, my expert opinion on this, don't think I'm bragging, I'm not egotistical, but I have researched this a lot. Because they put such a strict definition in the Canada Pension Plan Act to ensure very few people will get it, they basically got rid of the fact that you're supposed to get both. Now, what I'm referring to is a Hansard record from 1964, 18th of November 1964. A Conservative member of Parliament asked the Liberal Minister of Health and Welfare, Judy LaMarche. He said, listen, if a public servant becomes disabled, are they going to get a Public Service Superannuation Act disability pension plus the Canada Pension Plan disability? Now, he was hoping, or maybe he wanted to convince her she was wrong, he was hoping that she'd say no. But she said, yes, of course. If he has 5 or 6 pensions, he'll get them all. Now, that's the simple fact that legally pensions are property. So if you work for Company A for 5 years, Company B, C, D, E, and F for 5 years apiece, you had 6 companies, 5 years each, 30 years. At the end of your career, you will get 6 pensions, and none of them would interfere with the others because they're all your property. I don't understand where this guy, Chatham, I think, or Chapman, I could look it up if I cared. But the Conservative guy obviously wanted to save money at our expense by taking one into account with the other. But as I explained today and every other day, it seems, Canada has a retirement policy. In Canada's retirement policy, they built 3 things to act together or stack. The old age security, the Canada Pension Plan, and registered pension plans and savings. Those 3 things are supposed to add together to support you in your own retirement. Now, the thing is, in 1987, a guy who just died not long ago, Brian Mulroney, our former Prime Minister, he decided, and his government at the time, that they will put an income limit on old age security. So I posted about that today because I saw a YouTube video. I didn't watch it, but I saw this exorbitant amount that I said, that's not the right amount. They said you could, the maximum old age security is like $1,700 or $1,800. I said, I don't think it's raised up to that much money. So I looked up the figures, and sure enough, it isn't that high. Okay? So I posted about it today. Now, because Canada has that retirement policy, Brian Mulroney should not have put in an income test. Because all 3 things are supposed to work together, old age, Canada Pension Plan, and your own pensions and savings, you're not supposed to reduce the old age because you have higher Canada pension plan and higher pensions yourself, like because you did a good job in savings. It's crazy, but it was an easy sell to the public. Well, I presume it was an easy sell because they made the figure so high to get the old age security stopped. You had to make a huge amount of money that very few people, I would presume, get. I'm sure there are some people that have too much money to get old age security, but the average person, I'm opening up my Facebook now so I can see what the figures are. I like winging it because I don't have a script, but I don't want to, put my foot in my mouth, okay? So I want to look up the actual figure from the actual picture that I posted to Facebook observation post group today. Okay, so come on, system, hurry up. Now, I got so many groups, I got to figure out, go to the right group I created. Now let's see if I can find it fairly quick. Skimming down through, I post so much. Now, okay. They said the maximum is $713.34, okay? So that is the maximum. Everybody gets a flat rate for old age security. So I'm almost 100% certain that the YouTube video that I didn't watch was talking about the guaranteed income supplement. If you have low income, the government has a form of welfare, social assistance, call it what you want, income support, the government has for low income people, the guaranteed income supplement. So I'm pretty sure that that's what the YouTube guy meant. Now, I want to look at when to get old age security to cease, to stop paying, you would have to have, as of 2024, $134,626 in income. Now, I would bet a lot of money that very few over 65 people have over $134,626 coming in a year. Okay? But the government shouldn't have set even that high limit. Okay? They shouldn't have meddled in our retirement policy. Now I got that off my chest. Let me talk about the Canadian Forces Ombudsman and this failed report, I think, from 2003. Now, there's pros and cons to this report from 2003. The Canadian Forces Ombudsman, I'm starting to research it a bit, was established, I think, in 1997, 1998, around there. I think, as my expert opinion, all of this research I'm doing, that the government wanted to set up something to make it look like they cared, to look like they were listening, but they didn't give it any power. So if the Canadian Forces Ombudsman saw something that was going wrong, they could only tell the government about it and not order it to be fixed. That's a crucial failing. Now, when you're the boss, like the government, you don't want somebody given oversight telling you what to do. That's human nature. So, I'm going to go through the whole damn report, or at least part of it. I can follow it up later, maybe. So, the introduction says in paragraph 1, this report was prepared as a result of an investigation launched by my office in response to complaints received about the long-term disability insurance coverage provided by the Service Income Support Insurance Plan to Canadian Forces members who become injured or disabled. Paragraph 2. SISIP is a group insurance plan that makes insurance available to members of the Canadian Forces Regular and Reserve Forces. The plan operates as a non-public fund entity and is considered a division of the Canadian Forces Personnel Support Agency. SISIP also has a SISIP Financial Services Division, which provides financial products and services to current and former Canadian Forces members and their families. It offers financial counseling, planning, and educational services. Can't really disagree with much of that so far. Insurance operations, paragraph 3, under SISIP consists of two parts, SISIP proper and SISIP insurance plan supported by Treasury Board Secretariat of Canada. Now, there's where I would disagree. I'll go on a little bit more and then I'll tell you why. The resources available under SISIP proper belong to the Canadian Forces and fall under the direction of the Non-Public Funds Board of Directors. Well, I disagree with that entirely. It doesn't belong to the Canadian Forces. It belongs to the Canadian Forces members. That's a big difference. And falls under the direction of the Non-Public Funds Board of Directors. SISIP proper offers survivor income benefits and coverage after release. As of December 2002, more than 112,500 Canadian Forces members, former members, and spouses were insured under the various life insurance policies available through SISIP. Now, SISIP is a very big organization. It's bigger than Veterans Affairs Canada. Now, when people say that SISIP will disappear, I would say it's more logical that Veterans Affairs Canada will disappear before SISIP. They have a lot of insurance products and portfolios for billions and billions of dollars of insurance. What does Veterans Affairs have? A bunch of public servants, and they doles out money, even, they claws back things, and they treats people like shit, and they don't do, in the past, I was reading in the Hansard that they expected after World War II that so many decades in the future, Veterans Affairs Canada would disappear. Because their veterans from World War II would be outdated, and they wouldn't need a department. See? So this is another one of my theories, that they set the new Veterans Charter up to guarantee their jobs. They didn't do it to try to help out veterans. They decided that they wanted to increase supervision and put, a spy on veterans. They brought in rehabilitation, for example. Under the Pension Act, there was no rehabilitation. Now, they twisted that fuck around, and they said that, oh my God, there's a failing under the Pension Act that they don't give rehabilitation. Well, that's a good thing. You don't want somebody saying to you after you've been injured that, listen, yes, you were injured in Service Canada, but until you do exactly what we say, we're not giving you any money. That's not how compensation for injury works. You don't put conditions on a person who's been hurt by you and say, you're not getting the money until you do what I say. That's not how it's supposed to work. I better watch or I'll get too fucking upset with this shit. Now, paragraph 4. The resources associated with the remaining part of SISIP operation fall under the direction of Treasury Board. Now, let me explain a few things. Due to my extensive research, I consider myself the foremost expert in this field. According to the Veterans Affairs Canada research paper from 2005, they said that in 1982, Treasury Board assumed control of SISIP. Now, I presume it was either under the control of Maritime Life or the Canadian Forces up until Treasury Board took over control. They didn't explain that, but I'm left to infer facts from facts that they gave us. Now then, we know that in 1990, the Chief of Defence Staff assumed effective control of SISIP from Maritime Life. So we know that somewhere between 1982 and 1990, the Chief of Defence Staff took it back from Maritime Life. Now, then we get to 2019. On the 1st of April 2019, the Department of National Defence assumed control for SISIP from Treasury Board. Now, so between 1990 and 2019, Treasury Board took back control like it did in 1982. Now, here's the thing. Treasury Board is forbidden by federal law. National Defense Act, Section 41.3, states that the Financial Administration Act does not apply to non-public funds property. Now, because SISIP is non-public property, then Treasury Board cannot control SISIP. End of story. But according to the records, Treasury Board did control it between 1982 and 1990, sometime after 1990, up until 2019. Now, you shouldn't be allowed to break the law when you're the government. That's one of my theories. It's not my theory, it's rule of law theory. Now, the SISIP plans supported by Treasury Board. Now, this is another one that triggers me all the time, supported. They're not supported by Treasury Board. Treasury Board pays the premiums that are earned in service by the Canadian Forces member. Okay? So, if you earned it, it's yours. So because they make the physical payment, if they do, because I don't trust them, that doesn't make it a Treasury Board payment on behalf of Treasury Board. It makes it remuneration for services. Okay, so they include the long-term disability plan, reserve long-term disability plan, and a vocational rehab program. Now, you know I'm winging this, so excuse the odd errant thought, the divergent thought. SISIP rehabilitation is not mandatory. You would think that it is because everybody thinks it is, but it is not mandatory because insurance can't say to you, I'm not giving you your insurance money because you didn't participate in rehabilitation. Because the risk happens, you have to get the money, okay? You paid the premium for the underwriter to cover the risk of that you insured against. Now, if you become disabled, they can't then say, well, yeah, we saw, you paid the premium, you became disabled, but you're not in rehabilitation, so you're not getting any money. No, they can't do that, see? But they present it to people, including Veterans Affairs, and I've seen Veterans Affairs Canada's reports that said that it's mandatory under SISIP, but it's not, see? But if you look at the statistics, it's like 95% of the people on SISIP are taking rehab, and that's because they lie to us. Okay? They lie to us and they tell us you had to be in it, but you don't have to be in it because that's not how insurance works. Now, paragraph 5. SISIP describes the long-term disability on its site as a disability group insurance plan sponsored by Treasury Board that provides Canadian Forces members with replacement income if the Canadian Forces member becomes totally disabled or if the Canadian Forces members are released from Canadian Forces for medical reasons. Now, there's a lot to unpack there. Maybe some people might say there's not much to unpack there. But the long-term disability plan is, in reality, at least since 1999, a split definition disability plan, which many insurance contracts consider to be two separate contracts. The first 2 years is considered short-term disability. I'm not saying I agree with this, but that's what the consensus is. And then following that, long-term disability is only past 24 months. So the definition changes. At the first 24 months, you had to be, in military parlance, a 3B definition disabled. But to get it to age 65, you had to be 3A level disabled. Now, this is another thing I want to talk to the Ombudsman about today. You see, they keep talking about income replacement is the goal of the plan. No, it's not. All insurance is sold for peace of mind. So when you're healthy and you're paying the premiums for long-term disability, the goal, the object is peace of mind, that you know that if you become disabled, you will have insurance, whatever they want to call it, income replacement insurance, insurance proceeds, and it's money. But the money will give you the peace of mind. But the object of the insurance is not to get the money, because they try to avoid that by doing clawbacks, by not giving you the insurance if they can find a loophole. So I want to stress, if I ever get a hold of the Canadian Forces Ombudsman, that you need to try to get the word out to the Canadian Forces members that you're not buying income replacement. You're getting peace of mind. So if you go through your whole career, you don't become disabled, and then you can't look back and say, I wasted all that money on SISIP premiums, because you got a financial product and you got what you paid for, peace of mind. You're probably very lucky that you didn't become disabled, because then you'd find out you never had peace of mind, because when you go to get the money, they wouldn't give it to you. More than likely. Paragraph 6. According to SISIP's website, approximately 60,000 regular force members and 30,000 reserve force members are insured under the long-term disability policy. Now, you see, people are fast and loose with a lot of these words. But these are the words that basically the judge in the Dennis Manouche class action used, because when they were arguing the government, the Crown, it said the only insured party here is the Chief of Defense Staff. And Manulife is the insurer, and the Chief of Defence Staff is the insured. So basically, they left the Canadian Forces member out. Now, theoretically, there's nothing wrong with that, because they could say that the Chief of Defence Staff was acting as a representative for the Canadian Forces members, and they are beneficiaries under the policy. But that's not what the Crown argued. They tried to get the case thrown out, because in order to take a case to court on a contract basis, you had to have standing in court, and you have to be a party to the contract. So the government was saying that the soldiers never had a party, weren't party to the contract, and therefore throw it out, Your Honor. Now, the judge came up with an improvised solution, and they said that the de facto insured is the Canadian Forces member. They said, in fact, in the policy, it keeps calling the Canadian Forces member the insured, and that was their reasoning, and that's why I brought it up here. But if you look at what's on paper was what the Crown said, that the Chief of Defence Staff is the policy owner or the policy holder. That's usually what you call the insured person. But you see, the Chief of Defence Staff, he's not buying insurance for himself and that's it. I mean, it's insane. Anyway, now, for regular force members, Treasury Board pays 85% of the premiums while the members pay the remaining 15%. Bullshit. Pure, uncategorical bullshit. As I explained earlier, any payment related to your service is your money. And the fact that Treasury Board, if they pay it to Manulife, I'm not sure they do. But if they make a payment to Manulife or any other insurance company, they're not giving them money on their own behalf. They're giving money to the insurance company to insure the person who paid the premiums. See? So this is a sore point for me, a pet peeve. They keep looking at this and they try to say, for example, in the National Bank of Canada Federal Court of Appeal 2003 case, that we don't believe that this is a real insurance policy where Manulife is the insurer. They're just making the payments. But the employer is the actual insurer, they said. That was Canada Revenue Agency's position, accepted by the Federal Court of Appeal. But when the government got took to court, forget about the argument they made in the National Bank of Canada case 9 years previously. It seems to me the Department of Justice, and I called their office recently and I called them out on it, they seem to think that winning at all costs is the objective. I told them, even if I'm not a lawyer, if you're accused of doing something wrong and you did it wrong, you have a duty to settle. If you're accused of doing something wrong and you did nothing wrong, you have a duty to defend. So the Department of Justice, in the Manouche case, should have said on the first day, we have to settle this because we're wrong. Why were they wrong? Something that wasn't mentioned in this fucking report by the Canadian Forces Ombudsman. Federal statutory law prohibits SISIP from taking the Pension Act into account because Section 30, brackets 1.1, states that nobody can seize the Pension Act pension. Now, the Department of Justice, based on, I presume, their elected members of Parliament's orders, tried to twist that and say, we don't actually take it, we merely take it into account. That's not the same as a seizure, an execution. Well, it is. It's an indirect way of doing it instead of a direct way of doing it. See? So, one of the things that's on my mind, I'm always bringing up as an example. Okay, let's look at the Pension Act. In Section 25, if you were injured and you got a pension, but you also sued the person who hurt you. Now, if you're a civilian, it was a civilian that hurt you, the government wrote a law that would take half of the tort damages into account to reduce your Pension Act pension. But if you sued the government who injured you and you got a pension, they would take 100% of the pension into account. So you would, in effect, only get the damages in the lawsuit and not get the Pension Act pension. Now, why I was bringing that up is I did a column recently about the Salts British Columbia Court of Appeal case in 2006, and an RCMP member was harassed mercilessly by other RCMP members. Now, had she sued the federal government because she was an RCMP member, she would have been thrown out of court because of Crown Liabilities and Proceedings Act, Section 9. Because she was getting a Pension Act pension, she can't sue as well. But the RCMP had been hired, contracted by the province of British Columbia, so she sued the province of British Columbia, and the trial judge ruled that the Pension Act pension would be a reduction, will cause a reduction. It will be taken into account to reduce the damages that the province of BC had to pay her. Now, first of all, this is utter horseshit. Why should the province of BC save money because this RCMP member who became disabled and got a Pension Act pension in the service to Canada, which includes the province of British Columbia? Canada is a federation of provinces. So even though she didn't sue the federal government, BC is still part of the federal government, and Canada's federal government pays the pension. So therefore, there's a conflict of interest in reducing her damages paid by the province of BC, which forms part of the country of Canada, because she gets a payment through the Federal Pension Act. It's fucking crazy that they took it into account. But it's worse. Canada, in its infinite wisdom, passed several laws. One was a Statutory Instruments Act. Section 12 of the Statutory Instruments Act says that all judges across Canada shall take judicial notice of the laws that we elected members of Parliament pass. Perfectly logical law. Now, judicial notice, for those that don't know it, is that they have to notice it and just assume it's right. It's a law. Now, the problem comes with Section 25 of the Pension Act. If the judge had realized, the judge had two options as I see it. They could have said to the province of BC, you want to take the Pension Act into account. But I'm sorry, I'm a Canadian citizen, and the people that I elected, I voted, and the members of Parliament that we voted put Section 30, brackets 1.1, into the Pension Act. And that says that no award shall be taken in execution or, what's the other word? Anyway, there's two words that they use. Seizure or execution. Now, what they did was they seized the Pension Act. They took the value of the Pension Act into account and reduced the tort damages. So the judge broke Section 30, brackets 1.1. But they could have also said, I'm a Canadian citizen, I voted, people that voted, I voted for, they made laws and they put Pension Act Section 25 into account, and even though the province of BC wants to take this money into account to reduce its damages, the federal government passed a law that said it wants to take into account damages in a lawsuit in tort, and therefore the federal law, which overrides provincial law, takes effect, and therefore we have to convert the tort damage award into a monthly payment and let Veterans Affairs reduce the Pension Act, not the other way around. See, this is the classic example that I've been talking about, where two parties that want to save money at the other person's expense, and they're just ignoring the disabled person who became disabled because of somebody else's wrongdoing, and the judge didn't make it any better by being incompetent. I spoke to the lawyer for Nancy Wilson Salts, and I think I might have spoke to her as well, because I think that's an injustice. It shouldn't have happened. Now, carrying on, excuse me. Paragraph 7 SISIP long-term disability coverage is automatic for all Canadian Forces members who joined after April 1st, 1982. Now, earlier today I posted a little analysis of this first page, which I'm reading off again. Now I'm winging it, but I had some time to write, and I was there just typing away furiously. Yeah, it's automatic, but it's automatic because they took away the freedom of the contract. So in 1982, the Government of Canada passed a law, Queen's Regulations and Orders 208.53. Now, the Queen's Regulations and Orders are regulatory law passed under the authority of the National Defence Act. They don't have to be debated in Parliament. There are 3 different versions. Don't ask me all of them. And T is Treasury Board. If you see in brackets after each particular law, if you see a T, it's Treasury Board. If you see an M, it's Minister. And if you see a C, it's the Chief of Defence Staff. So they can write laws, plug it in there, and somebody decided, I think it's Treasury Board in this case, they decided that, you know what, that stupid freedom of contract, we don't like that because, you know, everybody's not paying premiums and we can't make as much profit. So we're going to pass a law that says you have to have the money deducted from your paycheck. Now, the problem is that you're supposed to be able to choose who you do business with. So you're not supposed to take away someone's freedom of contract. Now, that is, I'm sure, it should be a tort. Now, the problem is contract law and tort law are not exactly the same. Contract law is about agreements between 2 people that consent and form a contract. Tort law is about strangers. Because if a stranger hits you and they didn't observe the duty of care, then they were negligent and you can sue them to get damages. But what about if the Crown brings in a law that says you have to buy a contract? Before that, between 1969 and 1982, you could choose not to insure under the Service Income Support Insurance Plan. You might say, well, that's bad, or you might say that's good, but it was your choice. The government took away that choice. Now, I happen to be, because I consider myself to be an excellent researcher, I talked to trying to remember his first name now, but Andy. I was going to say Danny, but Andy Moyasenko. Now, he was serving at that time, and I said to him, I said, listen, seeing I'm talking to you, and I know you were in service around that time in 1982. Do you remember, or can you tell me about what happened when they changed they made it automatic, that you had no choice about it? Oh, yes, he said, they called us into a briefing room, sat us all down, told us this is for your own good, and then told us to leave. Now, that's not a very good way of doing it, especially when they really just want the premiums and they didn't want to pay with any insurance. See? Because if they were operating this insurance the way it should be, anybody who becomes disabled should get it. That's why you buy it. But Jo Gunny Gilland, she told me her story, and in 1985, when she became disabled, she went to the orderly room. She was asking about the SISIP policy and should she apply, and the people in the orderly room said, see that pen right there? If you can lift that pen, you won't get approved. Now, should they have told her that? I think they shouldn't have. In fact, Dennis Mamouche told me when I gave that story to him, he said, I would have applied anyway. Most people wouldn't, I don't think. If you're told by the experts, the battalion orderly room, or the administration experts, if you're told that it's not worth your time to apply, I'm pretty sure you're probably not bothered to apply. Now, the thing is about all this stuff is, like, I'm always so negative about this stuff. But really, if they operated it correctly, I'd be positive about it. Like, insurance is for peace of mind. So if you got the insurance and they didn't fuck you over with clawbacks, if they didn't fuck you over about the wrong definition to use between 1969 and 1999, that's one of the issues I'm trying to help Jo with. Because they used the 3A definition, and you had to apply to get it, and you had to have 13 weeks off without pay to get it. Very few people got SISIP at the very beginning, okay? Now, when they discovered, and they discovered this by comparing it to other long-term disability policies with the federal government, and they found out that people who couldn't do their own job got insurance for at least 2 years. That wasn't the way it was with SISIP. So they decided they had to fix it, which is only right and proper, because they were doing it wrong. So in 1999, they made it automatic on medical release. And they don't have a 13-week elimination period either. So the thing is, they never fixed it going backwards. Okay? If you did something wrong with 1969 and 1999, 33 years. No, 30 years. When you find out you're doing it wrong, you should fix it. You have a duty to make people whole. Okay? You don't just fix it on a going forward basis, which is what they did. Seems like the government's caught up in, and that phrase drives me out the wall, going forward. Okay? So they fixed the SISIP policy in 1999 going forward. They changed stuff, and oh, forget it. I won't try to remember other ones because I never planned to talk about that one. Anyway, let's have a look at the carrying on with that part about the premiums. Now, Treasury Board pays 100% of the premiums for Reserve Force members. Now, they pay 100%, but they pay it on my behalf. If I become disabled, I get the insurance. Treasury Board doesn't get the insurance. Only the person that pays insurance premiums gets the coverage. See? How do they keep missing that fact? So, I got into a racket manually about that, because I used to work for Canada Revenue. So I thought to myself, well, if I paid 100% of the premiums, I should be able to claim my premiums in accordance with Income Tax Act, Section 61F5. So I called them up and I said, can I have a copy of my premiums that I paid during my Canadian Forces career? But he said, what do you want that for, taxes? I said, yeah, seeing you brought it up. I used to be a tax collector for CRA, and I happen to know that you can claim your career premiums from a long-term disability policy before you get taxed. Your entire career's premiums come off first. Well, you didn't pay it. Treasury Board paid it. Listen here, you fucker, I said. You don't think they paid that out of the goodness of their heart. I earned that in service, you son of a bitch. I never got it, obviously, because they don't want to refund us the taxes. But it is not fair. Now, the other thing that I never said it to them, at least don't, maybe I did, maybe I didn't. When you pay 100% of the premium, it doesn't matter about the career premium because you get the entire insurance payment tax-free. So it was a sneak attack, okay? I told them I wanted it for the career contribution premium thing. That was Plan A. But Plan B was the total taxes had to be wiped out when it's proven that I paid 100% of the premium. Now, carrying on, as an example, a regular force corporal paid at the standard pay incentive 4 pays $8.05 per month, while Treasury Board pays $45.60 per month. Now you see the $45.60 is paid on the corporal's behalf. Other forms of insurance are available at additional costs. Now, paragraph 7. SISIP long-term disability. Oh, I skipped ahead. My mistake. I did that one already. Now, skip that one. Okay, paragraph 9 is the important one. Next important one. SISIP's website. Not a very good way to look things up if you're doing an investigation or rely on a website, I don't think. Especially back in 2003 when the internet wasn't that robust. SISIP's website states the Canadian Forces members who qualify for long-term disability benefits will receive an amount equal to 75% of their salary upon release, less other relevant sources of income. Now that, paragraph 10, I might as well keep going and I'll go back and do both. Given that Treasury Board sponsors the SISIP long-term disability coverage for Canadian Forces members, any changes to the policies and premiums require Treasury Board approval. Bullshit. Non-public property. National Defense Act, Section 41.3. But they put it there as if it's a fact, when it's total bullshit. SISIP manages the Treasury Board supported programs on behalf of the Crown, and Maritime Life Assurance is the insurer. Now, according to, still got a bit of that stuff in my throat from infection I have. According to the Manouche case, that's all lies. See? Because Manulife, at the time of this report, Maritime Life was the alleged underwriter, the insurer. But by the time the case went to trial, they had been bought out by Manulife. And Manulife was said to be, in effect, a stranger to the policy. Now, a stranger to the policy is the other party. First and second parties are parties to the contract, and the third party has nothing to do with the contract. Now, it just so happens that Manulife was hired to administer the contract, though. See? So they're actually part of the first party. They're the agent for the government, the Crown. So if you have a dispute with them, you don't have a dispute with Manulife as a company. You have a dispute with the government who's operating. They hired Manulife to administer the policy. I'm going to have to call her quit soon, but I'll try to get through one more point. According to Mr. Pierre Lemay, SISIP president, their statistics indicate at the end of September 1999, there are 981 active long-term disability insurance claims. However, the number of people who qualified to receive SISIP long-term disability benefits has progressively increased since 1999 due to the change in the policy. Now, that's the change in definition and the automatic approval on medical release that they're talking about. But here's the way they spun it here. On December the 1st, 1999, the criteria governing whether Canadian Forces members are eligible to receive SISIP long-term disability benefits was amended and broadened. So at the end of September 2002, SISIP had 1,791 active long-term disability claims. So then they get into paragraph 12. Since its inception, the Office of the Ombudsman has received over 50 complaints relating to the administration of the SISIP long-term disability plans and insurance benefits available to Canadian Forces members. A number of these complaints were resolved through changes in the criteria governing when Canadian Forces members became eligible to receive long-term disability benefits when they were implemented in December 1999. Others have been resolved recently by changes to the plan and legislation brought forward by the Minister of National Defence in response to concerns raised through the efforts of retired Major Bruce Henwood. I spoke with him. Me and him didn't get off. He seemed to think I was up to something, and he ended up hanging up on me. These much anticipated and welcome changes will bring the compensation. See, that's it. That's not compensation. SISIP long-term disability insurance is non-indemnity and contributory. Now, that means non-indemnity that it doesn't compensate. But there is other changes that, like a lump sum payment and stuff through SISIP, and that might be what they're talking about. So it says for families for dismemberment and permanent loss of sight, hearing, and speech. So that might be what they're talking about. So Canadian Forces, current and former Canadian Forces members also complained to the Office of the Ombudsman that the deduction of the amounts for the disability pension under the Pension Act through Veterans Affairs Canada from members' monthly and long-term disability benefits is unfair. Now, the choice of words, I think, is deliberate. Unfair is inequitable. And in law, there's a field of law called equity law, and that's about fairness, not about strict legality. So I think the Ombudsman was saying it was unfair rather than illegal. So he said the following complaint was chosen to serve as a framework for our investigation, and it was representative to the issues and concerns for the numerous complaints we received. The complainant served in the Navy 22 years. In 1989, he suffered a stroke and developed seizures that could not be controlled with medication. As a result, he was unable to continue working. Now, I don't like that word, working. The reason I don't like it in the context of the Canadian Forces is that the Canadian Forces members don't work, they serve. You might say, what's the difference? Well, in the United States back in the 70s, there was a drive to unionize the military. And it was beaten back by the government and the generals and all the bosses, saying that military members don't work for the government, they serve their country. Perfectly good argument, I think. This is why they're not recognized as employees in Canadian law. For example, the Canadian Human Rights Act deems Canadian Forces members and RCMP members to be employees. The Employment Equity Act also deems Canadian Forces members and RCMP members to be employees. Now, it's a matter of fact that if they were employees, you wouldn't need to write a law to deem them to be employees, right? So I don't like the word work, which is a civilian, what they do. Anyway, on February the 6th, 1997, he was medically released from the Canadian Forces under the Item 3A. Now, here's a comment, an aside on that particular thing. When I'm looking at the various types of release before, in the 90s, there were many more people that released 3A than today. Today, it's almost entirely at 3B releases. You might say, what's the difference? Well, I think, again, my expert opinion from researching this, that when the Canadian Forces released someone under 3A, they would have a pretty good shot at getting SISIP, because that was a definition that was used in the policy. So if they had released them under 3B, it's not likely they would have qualified for the long-term disability. That's my theory, and I'm going to stick with it. So, in the Table 2, Article 1501 of the Queen's Regulation Orders for Release. At the time, he held the rank of Master Seaman. Upon his release, he began receiving a pension under the Canadian Forces Superannuation Act. Of course he did, because he had 23 years in. It's got to be a 46% pension. After his release from the Canadian Forces, the complainant applied for the SISIP long-term disability benefits. Instead of receiving those benefits in the expected amount of 75%, upon release, being $2,301, the long-term disability benefits were reduced by the amount of his Canadian Forces Superannuation Act pension. Now, that's illegal. They might have put it in the policy, but Canadian Forces Superannuation Act Section 83 says that you cannot take a Canadian Forces pension. You just can't. But of course, the government ignores the law they wrote. Prior to suffering a stroke, the complainant had injured his leg and knee in a Canadian Forces-based sanctioned hockey game. While he was still a member of the Canadian Forces, the complainant applied to Veterans Affairs Canada for a disability pension under Pension based on the basis that his injury was attributable to his Canadian Forces service. His claim was denied. After he applied for the SISIP long-term disability benefits because of his stroke, which, by the way, don't matter, you get insurance because the risk happens, which is disability, not because of the cause of the risk, okay? You just don't. It's not the way it works, or not the way it's supposed to work. A SISIP representative advised him to reapply to Veterans Affairs Canada for a disability pension under the Pension Act. You know why he did it. He wanted to claw back, fucker. So the SISIP representative also suggests that the complainant might be more successful in obtaining a disability pension if he had legal representation. As a result, he hired a lawyer at his own expense. Those fuckers at SISIP are despicable. He had to pay a lawyer to get something for somebody else's benefit. He was successful in receiving a 10% pension for his leg injury. So the complainant advised the SISIP representative of the amount awarded by Veterans Affairs Canada in the Pension Act disability pension for his leg injury. The SISIP representative then advised him that this amount will be used to reduce the amount of his monthly SISIP payments. So get this straight. The SISIP representative got him to get a lawyer, got him to get the pension, and then turned around and told him that we're going to deduct it from your long-term disability. I think these people should go to hell. I mean, literally. They're going to hell because they have no morals. They have no ethics. The complainant felt that because his disability pension was for his leg injury and was unrelated to the stroke that led to his release and his SISIP long-term disability benefits, that the amount of the Pension Act should not reduce the amount of his SISIP. Doesn't matter, okay? It shouldn't matter. Even the Pension Act shouldn't be based on pensionable condition, okay? Because it's supposed to be, according to the Sarvena Supreme Court of Canada case in 2002, it's supposed to be based on the event that caused injury. It might have led to the disability, but the actual pension is based on the event that caused injury, not the disability that resulted from the injury. The complainant was also eligible for a Canada Pension Plan disability pension. As a result of the long-term disability benefits were further reduced. As well, he received approximately $3,500 in retroactive payments from Canada Pension Plan. SISIP demanded that it be reimbursed the amount of the retroactive payment. Since the complainant receives the Canadian Forces Superannuation Act, the Pension Act, and Canada Pension Plan pensions, he currently only receives $246.11 from SISIP. Now you see, this is the problem. They're trying to reduce their legal burden, but they're doing it by taking into account your earned benefits. Boatwarelli versus Flanagan, 1973, Ontario Court of Appeal says that is not on. But they're doing it again anyway. And here's how to get away with it. I'm going to make this my last point. So I'm talking too long and it's hurting my throat, and I'm sure I'm hurting your ears. The problem is, as I see it, they don't go to court and they don't say to the judge, Your Honor, we want to intercept the Canada Pension Plan. We want to intercept the Pension Act pension. We want to intercept, we want to seize, we want to execute on the Canadian Forces Superannuation Act pension. Because if they did, the judge would look at them and say, Are you fucking retarded? I'm bound by the law. Canadian Forces Superannuation Act, Section 83 says I can't do what you ask me to do. Canada Pension Plan Act, Section 65(1) says I can't fucking do what you want me to do. Right? I mean, the Pension Act, Section 30, brackets 1.1 says I can't do what you want me to do. So you're in my court wasting my fucking time asking me to do something that's against the law. I suggest you talk to your member of parliament. You ask the member of parliament to change the law so that you can do what you're asking me to do. Now, see, the problem with that is they're doing all this outside the courts. So they're getting away with it. See? So they're telling you that they can do it. They do it, and they don't seek court's sanction. That's not how debt collection is supposed to work. I collected debts for a living working with CRA. I couldn't just take things as I wanted them. I had to follow procedures. And if I wanted to seize someone's property, pensions are property. They ignore that. But if I want to seize someone's car or their cottage or something, then I had to go get a court order, just like any other debtor, creditor, I mean. Get the court order, then you'd give the court order to the sheriff. The sheriff would then get the property and put it up for auction. That's how you're supposed to collect debts. Now, what these people are doing is acting as if they have a court order when they don't have a court order, and they're getting away with it. Part of it is because they're the government, in many cases. Insurance companies are doing anyway, right? But this stuff needs to stop, okay? They're acting unlawfully. Any other person that tried to collect a debt that hasn't been proven in court would probably get thrown in jail because they haven't gone and done the legal process to look at. Hates to do it because some people love Trump. I hate him. Donald Trump has to pay almost $500 million, according to the courts in New York. The judgment is coming due on Monday. Now, they have a law in New York that says if you want to appeal a verdict and you have a money judgment against you, you have to put up the equivalent in a bond so that if the person, if you lose your appeal, you can't just say that I'm not going to pay it. You have to have the money there to appeal. Now, that law was brought in to protect people from people like Donald Trump, who would try to move their money out or go bankrupt or do something else to avoid paying the judgment. But my point is that there's a judgment that was in court after both sides had their chance. And that's the way it should be for clawbacks. If they want to reduce their payment at our expense, then they should ask the court's permission. They should bring it to court. They should say, Your Honor, I want to take this man's Canada pension plan disability into account to reduce our payment. And then hopefully the judge would have a clue, and he'd have to say, well, you know, if he has enough Canada pension plan to eliminate the payment, then why did he pay premiums? Like, isn't he paying premiums then? Paying money for something other than insurance? Because it's not insurance if you can't get it, if you claw back money to, you know, basically say that you have no risk. That'll be one point. Then if he knows the law, he hopefully would say, well, you know, doesn't Canada Pension Plan Act, Section 65(1), prohibit what you're asking me to do? And then hopefully he'd say, well, you know, in precedent law, you know, in past precedent, doesn't the Sarvena Supreme Court of Canada case come into effect that the Canada Pension Plan is a non-indemnity and contributory payment only paid to contributors? It's not like a government program to help people out. It's a social insurance. And you're asking that this person's property, because pensions are property, you're asking that this person's property be used to reduce his relevant income. You're saying that the SISIP policy pays out income, which, well, let me get back to that. Insurance money, insurance proceeds. So you want to reduce your insurance proceeds payment, your legal liability to pay under the contract, by the fact that this man has property that the government held in a government-sponsored social insurance. And because he's getting that, you want to save, so you want to get the premiums for nothing. Do I have that straight? Get out of my court, you fucking bastard. These people are the scum of the earth. They are taking advantage of disabled people. They're profiting on the backs of the disabled. Now, last point, I promised that last one was it, but one of the things I was going to mention to the Canadian Forces Ombudsman, because I didn't see it the first time, and even though I'm reviewing it again, I still haven't seen it. Did they take into account that a Pension Act pension is paid only to those who are injured in service? Shouldn't there be a special allowance made? Even if the entire insurance industry and all the other governments take things into account. The Pension Act pension is paid for an injury in service to Canada where a person puts their life and limb on the line, and you go fuck yourself if you want to use that to reduce your payment. Hope no one's offended by my person, but I think I got a good point. Anybody who tries to defend other people at risk of their lives shouldn't get treated like this. They're risking a lot of punitive damages. They're risking a lot of damages to their reputation. Backing up this shit when they should have just said we're wrong and then tried to fix it. Listen, thanks for watching, and hopefully, you know, I'll get this stuff fixed one of these days.